Welcome to the Savvy Dentist podcast with Dr. Jesse Green, the show where great dentistry meets great business. Listen in each week as we bring you an inspiring person who will share their story, ideas and business techniques to help you create a practice and a life you love. And now introducing your host, Dr. Jesse Green.
Hi everyone, it's Jesse Green here. Welcome back to SavvyDentist.com and to the Savvy Dentist podcast, the show where great dentistry meets great business. Really excited today to be having a conversation with Brad Wright from Dentalegal.com.au. And many of you know Brad because he's been around the profession for decades. Not only is he a dentist, of course, but he is a barrister. And what I really appreciate about what Brad does is his ability to combine his vast experience in the dental profession with the practicalities of law so that dental practice owners remain compliant at all times and on the right side of the law. So we did have a wide-ranging conversation this morning and we touched on a variety of things. We spoke about consent, what it really means and how to actually get it. We also spoke about contracts, when you're buying a practice or selling a practice, what are the common things you need to look out for? We spoke about dispute resolution and handling conflict and whether that's through mediation or arbitration. And we also just touched on a wide variety of different mistakes that people make legally as they go about their day-to-day operations of their practice. It's a wide-ranging conversation, as I said, and there's something in here for everyone. And as I mentioned earlier, I appreciate Brad's practical strategies. He's obviously a lawyer and a barrister, but he's also run a practice, so he understands those day-to-day things that need to be taken care of, and he applies the legal practice to dentistry in a way that I think is very elegant. So as always, do have a pen and paper handy because you're going to want to take some notes. And most importantly, you want to take action on those notes. Now, just before we get to Brad, a little advertisement. If you haven't yet joined us in the Savvy Dentist Facebook group, do join us. It's a dentist-only group there, and there's plenty of training, tips, and tricks in there for you. And you can, of course, learn to grow your practice that way. Now, if you want to find us there, head across to drjessegreen.com/Facebook and come and join the group. But for now, let's get on to our conversation with Brad. I really hope you enjoy this as much as I enjoyed recording it. Here he is. Brad Wright, thank you so much for taking the time to come and join us on the Savvy Dentist podcast. How are you today, my friend?
Well, thanks. A bit warm in Queensland, but otherwise it's operations normal, Jesse.
Well, fantastic. Well, you're in a nice part of the world there. When we were talking just off air, I was looking at the lovely views out your window, and you're in a nice part of Brisbane there, right central. So it's a good place, mate. You've landed in God's country, so happy days.
Well, I was born here, so I didn't ever really move very far away, so that's how it goes sometimes.
Well, Brad, you've probably got one of the most interesting backgrounds that I can think of when it comes to people who have been part of the dental profession. Obviously, you're a dentist, you've been a practice owner, you've served the ADA in various capacities, you've been the clinical operations manager at UQ, you've been on the federal council as well, and you're now a solicitor barrister. Tell us what that journey was like for you. Can you just give us a bit of the backstory? Because I'm always curious to understand what led you to make those decisions to get to that point.
I think it's just happenstance really a lot of the time. I think when I was a kid at school, I didn't really know, like a lot of people still say they don't know what they want to do when they leave school. And I didn't really have a legal reference point to talk to. So I kind of wanted to do law, but everyone else was doing dentistry, medicine. I didn't get into medicine, so I got into dentistry. But I did law fairly soon after graduating as an undergraduate degree, and it kind of sat there for a while. Then I got admitted as a solicitor, and then we sold our practice in Gympie in 2007 to Mark Cull up there, and I decided that there was an opportunity to do something else. So I worked at UQ, decided the UQ wasn't really for me, and I think they felt the same way. And so then I just went to the bar in 9 years ago now, and yeah, it's been great. It's just a second profession. I'll never be as good a barrister as I think I could have been a dentist because of time. But yeah, it's been good fun and I don't regret any of it.
Well, mate, word on the street is you're a bloody good barrister. So, you've obviously made some smart decisions and some good moves in that journey. So I suspect you might be much better than you give yourself credit for. I do want to...
Well, yeah, we'll see about that. I guess it's hard because as a dentist, just by way of example, you're only really going to have to impress your patient and your dental assistant and potentially a receptionist or a disinterested bystander. But as a barrister particularly, or any advocate, you've got to impress a decision maker, a judge, probably a solicitor, your solicitor, the client, the other barrister, their solicitor and their client. So you've got an audience where failure is particularly hard felt.
Yeah.
That's for sure.
Yeah, I'm sure, and public too.
Exactly.
So I wanted to ask you, before we get into the nuts and bolts of the legal type questions I want to ask you about today, I wanted to ask you about skills transference and whether there was any transfer of skills from dentistry to being a solicitor and then barrister. What have been, if any, the skills that have held you in good stead that you've been able to take from dentistry?
It's a really interesting question. No one's ever asked me that before, but I think about it all the time. I think one is organisation with time. I'm in a building with 250 barristers, but luckily the door's closed, and most of them are absolutely hopeless with time management, and most of them are absolutely hopeless with business management.
Yeah.
So those two skills that I learned as a dentist and through some other study have been helpful because I am good with time, and I like to think, and I am good at understanding how business operates and profit and loss and tax. And many of my colleagues here just don't get that. And I think that's the wider community, not just lawyers. But yeah, they would be the two things. I think time management and business understanding. And, of course, talking to people.
That was what I was going to ask. What about, dealing with the anxious patient and then dealing with a stressed out client?
Yeah, much more about how to get people on side. Anyone who's been doing dentistry for as long as you and I have. I'm not putting you in the same ancient category as me. But
I was just about to object to that, but anyway.
But anyone who's been doing dentistry for a while, shall we say, Jesse?
Yes, long enough.
Developed some skills and tricks and abilities to deal with people. And I have to say that many of the bar in all jurisdictions I've appeared in a number, and I'm not trying to defame the legal profession, but they don't have the training and understanding of one-on-one communication because, let's face it, dentistry is unique. You're sitting less than 30 centimetres away from someone inside their personal zone, and if you can't learn how to do that properly over the years, then you're probably not going to succeed in any profession.
Yeah. Yeah, I'm really, really, really interested to explore that a bit further. We'll come back to that in a second. But I guess as you've owned a practice and then you've moved into other roles, you would have seen quite a few things change over the years, and I'm sure the never-ending supply of things that shock and surprise you. When you look at dentists today, compared to when you and I graduated, what are the things that
you were 20 years after me, Jesse?
No, actually, I was going to object to that earlier, but I was reflecting on it going, I think I'm much closer in age to you than I'm admitting. But I'm really curious to ask you, what are the things in dentistry today that surprise you?
I guess the lack of appreciation of responsibility by some people. I talk to people and see things that others don't, of course. But it's fair to say that the dental profession, like all professions, I have to say, is spread from one end to another in terms of understanding of professionalism. So we'd like to think that professionalism was far more common and well understood in the 70s, 80s and 90s, and that it's less well understood now. And I think to a degree that's true, but there's always been people in the profession who are outliers. And some of the things I see on things like DPR make me cringe. And as I think I said once to someone, if you can't understand this, then leave the profession and sell used cars, because I think some people really should do that because it just brings the whole profession down if people don't get the basics. So I think I'm constantly amazed that people don't understand that when you are a dentist, it's not only a privilege and a responsibility, but you're there and you're highly regulated because people trust you because they don't know what's going on. And that's really all professions, that people have a consumer right to be informed because you are the expert, whether you're a dentist or a lawyer or a physiotherapist or a financial advisor, and you have an opportunity to take advantage of people, and you need to make sure that that doesn't occur.
Yeah. Do you think that there's more of that happening today then? Do you feel that, with this, reduction in professionalism in some quarters, that the public are less protected than they were in the past? Is that what you're getting at?
I think the detection of safety issues is much higher. I do have to say that I think the regulators, particularly in some jurisdictions without naming any, probably go a bit too hard on some things and let the bigger issues go.
Yep.
Someone told me a story last night, for example, by way of example, that there is a practitioner somewhere who is an excellent clinician by all accounts, but doesn't see the need to write clinical notes of any sort.
Oh.
Now, I've come across this a number of times over the last 10 years, and that is a bad thing for obvious reasons. But the problem is that unless a complaint is made, then that person may never be detected. Now, I would say that's a big problem. But then someone else who perhaps advertises something or conducts some aspect of their practice differently that gets some attention will suffer at the hands of the regulator, whereas someone, the broad profession, what I'm trying to say, is only regulated on the basis of complaint. And if people are really bad dentists and doing really bad things, they generally will get a complaint. But there are outliers who will just sail through, and that's a shame, but it does happen.
Yeah, true. And of course, there are also really good dentists who still get a complaint because of, some, perhaps communication breakdown or something happening adversely. Even the best people have a complaint from time to time. Yeah.
Even average dentists like me have had a complaint against them, and people don't like talking about that, but I can because I don't care. But I had one some years ago. It was dismissed, but even though I was a barrister even then and had to write long submissions, I didn't enjoy the process.
No.
I had one made against me as a barrister, which was dismissed, but that's going to happen, and people need to harden up and understand that there's no right to not have a complaint made against you. Yeah, totally. People are free to do it, and, you've got to let the process be followed through. And once people accept that, it becomes much easier to engage in professional practice and just take the highs with the lows, because there's going to be plenty of both.
Yeah, and just on the subject of hardening up about that, because, I agree with that, but on a practical level, how do you build the resilience around that? Because, as dentists, we're all perfectionists, most of us anyway. We all tend to see our own faults very, very clearly. Certainly, I remember going through UQ and being regularly told how incompetent I was, and as a student, that would have been fair enough. But I guess most dentists are fairly self-critical anyway, so when a complaint does come, it can be crushing for some people. It really does affect their self-esteem and self-worth. So how do you build the resilience around that? It's fine to say, yes, it's a process that's got to be worked through, but how do you let it wash over you?
Well, what I observe, personally, I think that it is confronting, and the first one is going to hurt. But what I do see with people, particularly dentists, I do occasionally deal with solicitors with complaints, professional issues, but typically with dentists, the first one really hurts, the second one less so, the third one you don't even notice. So to some degree, it's a school of hard knocks. But I think understanding the consumerist basis of how health practice is regulated is helpful. And if people truly understand that it's about protection of the public, and if someone makes an assertion that there's a safety issue, the regulators, whether it be the Office of the Health Ombudsman in Queensland, the Dental Board of Australia through AHPRA, or whether it's the Dental Council of New South Wales or any other entities I've forgotten about, they all have a positive obligation to investigate or at least assess. So that is just a fact of life, and has been the case since 2010. So going back to the original point, there is a lot of unprofessional conduct. I suspect there was a great deal more in 1983 when I graduated, but the detection was minimal. You really had to kill someone before someone would do anything about anything. Yeah,
fair enough. So I just want to change gears for a second and really step into your world a little bit, as best I can at least. And I want to ask you about a few common scenarios or a few legal things that you encounter. And I guess I just want to ask, my opening question around this is fairly broad. And what's the dumb stuff that you see dentists doing from a legal perspective?
Well, one that just came to mind, again, with another conversation yesterday, is delegating the responsibility for financial control in a practice to a staff member. That's not a legal issue. It is if the person defrauds them, which they more often than not do. But that's just a derogation of duty where dentists can't be bothered and they pay the penalty because people steal money off them. That's just one that I see regularly. Not understanding the consent process and how to get people to understand what they're doing, and, to be frank, not comprehending that it's not about the dentist, it's about the patient, and clinical notes are written for the benefit of the patient, not for the dentist. And those simple things that would be there's a whole range of stupid things people do, and we could probably be here all day as long as I was careful not to identify anyone. But, really not understanding why you record clinical notes and how you can be sure that people have had a reasonable chance to understand the treatment. They are two things that just constantly arise.
So can we just pick up on the topic of consent? Because, again, I see on various Facebook forums, different people outlining their process for consent. And for some people, it's a 20-page form filled out in triplicate. And for others, it's a conversation about, here's what could go awry, and I'm making a note of this in my clinical notes.
Yeah.
What is an appropriate procedure to, give people, the consumer, a reasonable chance of understanding the treatment and all that it entails?
It probably depends, Jesse, on the sort of treatment. So we should probably pick a treatment and then just maybe, if you want to, work through that. So whether it be orthodontics, wisdom teeth extraction, implant placement, or porcelain veneers,
when we look at
areas. So
why don't we pick on implants? Because that's an easy one. There's a bit of surgical stuff involved. There's a bit of prosthetics involved.
Yeah. So in terms of, can we talk about records and consent? Because they are pretty closely intertwined.
Yep.
Just off the top of my head, without preparing anything, my thoughts about implants are, number one, you can't do an implant without having done a full, proper, comprehensive oral examination, including radiography, caries, risk, periodontal charting, because to do other than that is to not give the patient a chance to have a full assessment and see whether that implant is really the most important thing they should have done or not. And I see all the time people jump in to do an implant without a full, proper treatment plan and assessment of the patient generally.
Wow.
So you should not do an implant unless all the primary and secondary disease is taken care of. There's no emergency. No one's going to die from a lack of titanium or acute porcelain deficiency. So this concept in people's mind that they must do something first is absolutely misapprehended and fraught with danger.
Yep.
So if you're going to do complex treatment of any sort, whether it be orthodontics as a general practitioner or otherwise, or whether you're going to do implants, then you need to make sure you've looked at everything else first. So that's number one.
Mm-hmm.
The second thing is that if you are going to do an implant, you have to self-assess, in my view, as to whether you are competent to do it, whether you've been trained. So whether, if it goes wrong, you could evidence to the patient, or should do in any event, that you've had some training to do it. So a very simple premolar, upper premolar, where there's no sinus involvement, with a CT scan that shows that's the case, with low aesthetic demands, is an excellent place for a practitioner to start that hasn't done an implant before. But to be doing multiple aesthetic zone implants where bone availability and quality is at issue is not very smart.
Yeah.
So once you've gone through that process of self-assessing, having done a comprehensive oral examination with the results of that, so you've done the examination, the diagnosis, and the treatment plan, and this can take, very short time, but the steps need to be followed. And then I guess we get to the guts of the consent, and options need to be given to the patient for treating that particular malady. So if the malady is a missing front tooth, then people are duty bound to go through, the options of doing nothing, the options of a bridge, the options of an implant. And finally, I think it behoves everyone these days to give the option of referral to a specialist, simply because patients will be understandably upset if something goes wrong with an implant that could have been treated likely more successfully by a prosthodontist or a periodontist or even a maxillofacial surgeon. But I do think that people need to advert to whether this really could, should, might be done better by an appropriate specialist.
Yep.
Now, that doesn't mean the patient has to go and see the specialist, but you have to give them the option.
Yep.
And if they say, no, I trust you and I'll do it, which is what most of our patients say, Jesse, I think it's fair to say.
Yep, they will.
But I do think that cost disclosure is important, and then all of the issues that arise in terms of things that can go wrong. And if it's something that's high risk, like an implant, then I'd have a pre-printed sheet, which I know the ADA and others provide, that lists all the complications. Particularly, I think one needs to go through that list face-to-face with the patient and perhaps talk about some of the risks that are more material and likely to occur than others. And then once the patient understands that, again, that might only take 15 to 20 minutes. then you may be in a position where you've got preliminary consent if the patient says yes to the finance and to the long-term outcomes and the risks and benefits. And once that's done, I guess it's important, according to Rogers and Whittaker, which is the famous case from 1992, is to think about the patient's particular circumstances and whether there's something that you know about that might go wrong that they haven't asked about that you should address. So, for example, with implants, they may have difficulty cleaning, so you might need to go into some detail about cleaning, periodontitis, risks, problems with adjacent teeth, things that you as a dentist would know about that the patient may not have thought about. So I think if the highlights of that, without going through and boring everyone witless, and including yourself, would be do a proper exam, break up the examination and the treatment plan, discuss the treatment plan and options, and then once that's done, go through the consent process. And I think people think you're quite right, Jesse, that the consent process is merely giving them a long form to fill in and sign. And signing that form is merely evidence that someone signed a form.
Yeah.
It doesn't consent. It's probably useful as a defence strategy to do so in complex cases, but that is not as good quality consent as a one-on-one conversation where the patient's had an opportunity to ask questions and have them answered.
Yeah. Okay, cool. So I want to ask you a little question about when things do go awry, because, I think if you've been a dentist long enough, you're going to have some treatment fail. And I was talking to some young dentists last night. It's about how humbling it is to see some of your best work fail. And, if you're doing complicated treatments, then, clearly the risk of failure is going to be higher. So the question I want to put to you, Brad, is probably twofold, is dealing with things when they go wrong. How do you, deal with the dispute resolution process, obviously informally and then potentially formally? And then secondarily, if you're a practice owner, where does your liability begin and end for your associate dentist?
Again, they're very good questions that will probably take up the rest of the interview, but we'll try.
Okay, sorry, mate.
No, that's okay. It's interesting to me. So when we talk about a dispute, this typically can be as simple as a patient ringing the receptionist and saying, Brad did a restoration or a crown on the posterior back tooth and it's sore. Can I come in and see him?
Mm-hmm.
And, that's the first phase. And of course, one should always have time set aside in one's diary to deal with patients who have spent money and are unhappy.
Yep, definitely.
And, that's, I'm sure, as far as your management and consultancy knowledge, you'd urge people to do that as well.
Definitely.
And so if people are listened to, they are not going to be likely to complain. So that would be the first step, to assess it and take the problem seriously. And again, these are the things people don't do. Probably one preventive measure, and I think you agree with me, I think I've spoken about this before, Jesse, is that post-operative phone calls should be made for these matters. Yeah. So if someone's had an implant or a crown or something that involves local anaesthetic or a procedure that's unknown to the patient, then a phone call stating that you want to follow up and see how they're going in relation to that particular tooth is a great preventer of complaints. And, of course, most people don't do that.
Yeah.
Most people will ring people if they're scared, or they'll ring people if they've done some complex extraction that they think the patient might die of in a lonely hospital bed that night, whereas it should be a matter of routine. So if you take those two preventive measures, being post-operative calls and also never denying a patient an opportunity to make a complaint to the dentist, so the person who provided the treatment, are really critical. And if people did that more often, that would be a big help in dispute resolution, because people need to be heard.
Mm.
And if dentists just thought about what would happen if they went to, well, there's nothing analogous to a dentist, but if they went to a doctor to have a minor procedure done, the sutures fell out, they're bleeding, they're in pain, they're not going to die and they don't have to go to hospital, they would like to be heard.
Yeah, totally.
So that's just human nature, isn't it?
Yeah, absolutely.
But the next step, I guess, is what happens when there's a complaint, and that's normally delivered by way of correspondence. It can come from a lawyer, it can come from the patient, or more likely these days, because it's so easy, it's a notification to the regulator, being, one of the three regulators mentioned before.
Mm.
Unfortunately, once it goes to the regulator, particularly in some states, they are duty bound to assess. So you should do everything you possibly can to avoid a complaint being made to the regulator, because that means that you will have to spend some time filling in paperwork. So if you can prevent it, that's great.
Yep.
But in the event that you can't, some jurisdictions, I know that the Office of the Health Ombudsman in Queensland will receive complaints. It will decide whether it can be resolved by early resolution. And I know the HCCC in New South Wales does the same thing. And I think that the health complaints organisations, which are not the same as a regulator in each state, do have those options. But it's fair to say that if a patient is unhappy and the dentist considers that the outcome perhaps was not ideal and at least some of the responsibility for that could be sheeted home to them, refunding fees usually will mean that a complaint will not be made.
Yeah, fair enough.
And, you know, if you are running, not you, Jesse, of course, but if a listener is running a practice where they can't afford to give back the money for a crown, then they probably need to look at the profitability of their practice, because giving the money back for a crown or implant on a without admissions basis is very important as a strategy for dispute resolution.
Yeah, totally agree with that. And it also, that ties into your pricing structure a little bit as well. You've got to be able to, you know, allow for, you know, contingency and, as you've said, run your practice profitably so you can do that. And, you don't want to be kind of scrimping out your last $5 to pay someone back their crown fee, that's for sure.
Well, the trouble is, of course, that people don't run their practices these days for a whole range of reasons, Jesse. And, you know, 10% of everything you do is going to fail without reason every 10 years.
Yep.
So, you know, that to me means put 10% on top of what you think is a comfortable fee to allow for the 10% of things you're going to have to give money back, because, you know, in 30 years of dental practice, I guess, actual clinic, was it 30 years? Maybe 34 years. I had a lot of complaints from patients about things, but I resolved them locally where possible. And I think the ability to locally resolve is a reflection of communication skills. And, you know, I don't consider myself to have been the greatest dentist in the world, but I was able to communicate, and that made a lot of things easier for me.
Yeah, love that. So let's just assume for a moment that you've got an associate dentist and this situation has unfolded. As the practice owner, how knee-deep in it are you?
Well, that's never been tested. It's been mentioned in OBITA in a couple of cases, as in not the ratio to decision that I've read, and I've been involved in a couple of these. But to answer your question, my argument, if I were the employer, would be, well, I got 60% of the fees, arguably. Let's use rough terms.
Yep.
You got 40% of the fees. So, but it was primarily your responsibility as to why it failed. So you should refund the fees and I will contribute to that refund. So I'm not saying that 40% should come from the employee and 60% from the employer, but there would have to be some adjustment.
Yes.
In vicarious liability terms, which is, you know, really a civil issue, if someone is to ask for money back because of negligence, then it might go down a 60-40 line. But in a regulatory environment where it's not as simple, because it's not always clear to people that there's two areas of risk. There's the civil risk, where if someone says you're negligent and you need to pay me some money back for your failed treatment, and then you've got the regulatory risk, where as a regulator will use words such as unprofessional conduct, professional misconduct, inadequate professional performance. All of these things amount to similar things. And I think that people need to understand the difference between the two, but ultimately the resolution is the same, and that is patient has to feel as if they're listened to and that the outcome is fair and equitable in most cases.
Yeah, fair enough. And is there any variation in that, whether the associate dentist is an employee on an SFA or a contractor arrangement? Is there any change to that at all, or is it one and the same?
I think there's attempts to escape responsibility on a vicarious liability from employment status, but when push comes to shove, most dentists, in my view, are engaged as employees. They work as dentists within a practice, and if a court were to look at those arrangements, as they do periodically, they would say that the dentist is an employee, and therefore they get all the benefits of being an employee, including vicarious liability being sheeted home to the owner of the practice.
Yep.
It would be a legal point to be argued, and it's quite nuanced, and I don't think that it's as straightforward as people think. But, you know, your typical thing is the patient comes in, wants their money for a crown back. There should be a policy, perhaps, between the dentist and the employee or worker dentist to potentially refund the money on some agreed basis. But, you know, that would be a way for the dentist who did the treatment not to be at risk. But similarly, I see more and more of practices where both the employer or the owner of the practice or the facility and the dentist who was actually the registrant who provided the treatment both get dragged into cases. So the idea that if you don't do the treatment, all you do is provide the facility gives you absolute protection is no longer true.
Okay. It's really interesting. You used one of my favourite words a moment ago, and that's nuance. And I'm a bit of a believer in the world that's full of many shades of grey rather than black and white or binaryism. And I want to ask you a question, and it may be a black and white question, it may not be, I don't know. But the topic around contracting versus employment versus SFA, you've alluded to the fact that generally you view most dentists on an employment type arrangement, and yet that's not the legal instrument that's typically used for many of those people. So I want to ask you, do you see that there are issues with SFAs, contracts? Should we just be employing everyone as employees and just getting on with that? What's your view on that kind of situation?
Well, it is nuanced. You're quite right, in my view anyway. And if you look back to how the history of this matter, it's my understanding, and I've not heard differently, but I could be wrong, that the reason that people are on independent contractor agreements or service and facility agreements is to escape the responsibilities as employers, which are twofold. One is leave entitlements, the Fair Work Act, meaning that if you want to sack someone, you have to do so pursuant to the code or to the Fair Work Act more accurately.
Yep.
So that was a reason that people got driven away from employment agreements, because dentists don't like confronting people normally and don't like terminating people, and so therefore they figure that a breach of contract is much harder. That's one reason. Second is that there are consequences for payroll tax if someone is an employee and you have multiple employees, and as you know, once the threshold's around about $1 million from grouped entities, then there's a responsibility for payroll tax. So they're the reasons, I think, plus perhaps just young dentists being, with the greatest respect to any listeners who are young, stupid, and thinking that if I get the money up front, then I can spend it and worry about the tax later. So those factors, one factor from the employees wanting to be able to lease cars and other things, the other from the employers wanting to escape liability, the other two reasons why. So at some point, there's been a progression to respond principally to the payroll tax issue by establishing these service and facility agreements, which purport to be arrangements whereby someone uses a facility for a fee. The principal of the agreement is the service facility owner, the dentist, and the subjugated position is that of the person who provides the facility. So it's an attempt to reverse the arrangement. That's been demonstrated not to be that effective in certain cases, because as the courts have said time and time and time and time again, that if you were to have this tested by a court, the last thing they're interested in is the contract.
Yeah, okay.
They're actually interested in the factual matrix around it, like who worked when, who did what, did you wear a uniform, have you got a business card, is there any goodwill associated with it? And these things are issues that arise. So, and to answer your ultimate question, yes, I think dentists should just suck it up and employ people. It'd be much simpler.
Yeah. It's a really interesting thing as someone who does employ people. You touched on something that I think is really interesting, and that is the younger dentist, the recent graduate or someone who's been out a few years coming in expecting, almost demanding to be on a contract arrangement or an SFA rather than being employed. It's quite an interesting dynamic, because for some of those people in their minds, they believe that if they're not on that arrangement, they're getting a worse deal than their peers. And, when you're in a competitive market for talent, there comes certain amounts of pressure to engage in that kind of arrangement. So, yeah, it's definitely a complex issue. But I guess what I'm hearing you say, Brad, is if it walks like a duck, talks like a duck, it's a duck. So they're an employee.
Yeah, that's absolutely true. And look, if people insist on being on contract arrangements despite everything else, I would just get an indemnity in that regard. And I do that for people periodically, is draft indemnities. It's not my favourite work.
Yeah.
But, if someone insists, so if you were in the unlikely event you said to me, Brad, help me with this, what do you think I should do? I'd say, well, I'd get a deed that says that you want them to be an employee. They refuse to engage with you as an employee. You want them to work in the practice. And despite all that, because of these recitals, we agree as follows. And one of those agrees would be, and I don't want people to take this as legal advice and draft it themselves, because there are some elements in this that are somewhat, to use the word of the day, nuanced.
Yes.
You would get them to execute a deed in your favour that in the event that they were claiming to be employees, then that would be a problem for them, which could be dealt with by the deed. And I see that's the solution to that particular problem.
Yeah, cool. So I do want to ask you one other legalese type of question, which comes around contracts for sale. You know, when someone's buying a practice, obviously there's a contract that needs to be created. And I wanted to ask you really quickly what you thought were some of the common pitfalls from both the vendor's perspective and the purchaser's perspective in that area. Where do people come unstuck?
Look, I have been talking about running a course on this for a while, because I know that lots of people run courses on how to buy practices, but I think what I would call is due diligence is sadly missing.
Yeah.
And because I see the end of it when it all goes to dust. So, yeah, I think that maybe we can talk about that and split that into two categories. So the first one is will we talk about sellers or buyers first?
Oh, you choose, mate.
Well, let's say seller. So if you're a seller, obviously you're trying to get someone to pay some money for something, so you don't really care too much. But things that are in contracts around that would typically be about representations that people are registered, that people are, going to give indemnities and warranties as to fitness and a whole range of other things. But I see that the buyer beware saying caveat emptor is far more applicable. But there have been occasions where sellers have sold to people, and, the principal thing that happens is people don't fulfill their obligations under the contract, whether it be by way of not employing the principal afterwards, or not engaging with the principal afterwards, or trying to sack the principal. And I know of that happening in legal practices and dental practices, and where people aren't paid, where people have, a golden handcuffs to keep the principal there, but then terminate them and the principal never gets paid. So those things do occur. By far and away, the most important areas are buyers of practices, because as I think I've heard might have been someone on DPR saying there's a lot of really, really bad practices out there. That doesn't mean they're not opportunities, but you want to buy them on terms that are acceptable to you. So to foreshadow what your questions might be, what are the, let's say, top 5 things that I see buyers, I should say, not consider when they buy from someone? Is that a good? Yeah,
I think that's perfect. That's exactly right.
So first thing would be lease, security of premises. So a registered lease, preferably a fresh lease, or at least get a lawyer, a solicitor, because I don't do this work. I mean, I advise solicitors about it, but I don't do the work because I'm a barrister. I don't go down and dirty with sales of practices, but when people have problems, I do. So my thoughts would be get a competent commercial solicitor who's dealt with this before. If you don't think the solicitor knows what they're doing, then find someone that does. If you can't do that, then ring me and I'll put you in the right direction. But you need to have a competent solicitor who understands the basics of exchange of title, registration of leases, and other licenses that go with it. So, for example, all the things like high caps, terminals, or the equivalents thereof, and bank accounts, all those things need to be addressed. So that's the first thing. The second thing would be understand, and you know more about this than me, or at least we have similar knowledge about what the value of the goodwill is that you're buying and what is in those books. So the worst case is buying a paper-based practice because you cannot, and I have bought one, and it's very difficult to analyse the value of the practice. So I think that paper-based practices must be discounted because of the risk involved in people buying them as a valuation proposition. And you need to have someone with expertise such as yourself, Jesse, or someone else run through the database and look at critical item numbers and occasions of service and work out what the likelihood is that these will transfer, because you don't want to pay something that for goodwill you're not going to get.
No, totally.
Employees are a problem. I see dentists take on employees as a matter of right, where there is, under the Fair Work Act, there is an opportunity to not take on employees or take them on and be able to, which is not commonly known. You can take on employees such as a dental assistant or someone else, or a practice manager, and restart their period of service, so that although they have long service leave and holiday leave, you have the customary 6 to 12 months to make a decision as to whether you're going to terminate them or not. So I see people, I've seen some crazy things where people are locked into that over the years. So get some advice from someone who knows about employment law and transitions of practices to that extent. So they are probably the big three. I said 5, didn't I? There's so many. I'm just trying to think of the majority ones. Preferred provider contracts, which is a live issue at the moment because Medibank, I should say, particularly, have been in positions where they will not. And I've never had a preferred provider practice. Well, actually, that's not true. I did. I bought it as a preferred provider practice and kicked who was it? What's the MBF? What's the equivalent of MBF? Bupa out.
Bupa, yep.
So it can be done. But what I'm trying to say is if you're buying a practice and the goodwill is contingent upon the health fund arrangements, then you really, really need to be very careful because there's no guarantee that they will transfer. And I guess finally, liability for issues that have gone on in the practice. So if you buy a practice off someone and you haven't done a good assessment and due diligence of the database and the patient treatment done, if someone's doing, for example, orthodontics is just constant pain where dentists are doing GP orthodontics and whether it's one school or another school, whoever looks at their work is going to criticise it, want to start again.
Yep.
Do you really want to buy a practice that's got a ton of incomplete and possibly inappropriate orthodontic treatment and have responsibility for that? Because you may well point the finger at the previous dentist, but the patient considers that you've bought the practice and it's going to be your responsibility. So they're probably the 5 things that would keep me awake at night if I were buying a practice.
Yeah, fantastic. I think that's a really great list. I'd like to just ask you about one other one that just popped into my mind as you were speaking. What about registered business names and all those sorts of things, transference of those, and whether they have a registered business name in the first place, which I know they should, but oftentimes it's missing.
That should be a problem more than it is, but it isn't. I mean, I think you're right that sometimes people don't think of that. So web addresses, Facebook page access, passwords, all of those things is a significant part of buying of a practice now, and how often they aren't addressed. And most times it isn't a problem because reasonable people will come to reasonable agreements.
Yeah.
But, if you don't know the person, I think it's a big difference if you're buying a practice from the person you're working with.
Yeah.
But if you're buying a practice cold, you need to do some due diligence. And I sometimes say to people, why don't you just ring up someone in the same town and just get an idea as to what their reputation is. Now, of course, some people will just slag off people all the time, and you wouldn't have to make too many phone calls for people to tell you what an arsehole I am. But the point is that you make a few phone calls and you can get a feel for what the practice reputation is. And I would certainly be doing that, whether I'm getting a job in a remote town as a recent graduate or whether I was buying a practice sight unseen.
Yeah. Brad, we have covered a lot of territory today, mate. And firstly, before we get into that, I want to say you are definitely not an arsehole. You're one of the good guys, mate, and I really appreciate you taking the time to spend with us today. It's been comprehensive, it's been informative, it's been entertaining, and really, really helpful. Ladies and gents, Brad Wright, if you want to take him up on his advice, find him at dentalegal.com.au, dentalegal.com.au. I think the work that Brad does for our profession is outstanding. He's been a huge service to the profession over many, many years, and from all of us, Brad, I want to just say thank you, not just for this interview, but for all that you've contributed to the profession, which is vast, and we really appreciate all that you do. So thank you, mate.
Well, it's very kind. I'm not sure it's all true, but thanks anyway, Jesse. And I hope it's been of help. And people can feel free. I often speak to people for 5 minutes and get their problems sorted. And that's a lot of what I do because you just try and help people out where you can.
All right.
Sometimes it costs money, unfortunately.
Sometimes it does, and it should too, because you need to pay for good advice, and that's what you're about, and that's what I think is we all expect to be paid for what we do. I think it should be the same when we engage the services of experts. So great stuff, mate, and thank you once again. I really appreciate you taking the time. You're a good man.
All right, all the best, Jesse.
Thanks, mate.
Thank you for listening to the Savvy Dentist podcast with Dr. Jesse Green. For more free tools and resources, join the free Facebook group. Visit drjessegreen.com/Facebook. And for more episodes, visit drjessegreen.com/savvydentist.